Friends, if you are watching this video first time, then please subscribe to this YouTube channel, press the bell icon notification button and like this video so that we can update you from time to time. Friends, there is another judgment passed by the Honorable Supreme Court of India. It's Civil Appeal number 4455 of 2012. It's an appellant versus State of Assam and others is case title is, and the State of Assam and others are the respondents. So, important issue which the Honorable Court has decided whether the person whose appointment is declared is as illegal, whether he or she is entitled for their services which they have rendered to any institute. The Honorable Court has decided this issue. Let's see the contents which are available in the judgment. This was a writ petition was filed by the appellant in Guwahati High Court in year 2008, praying for release of her salary from 2001 onwards. It means after 7 years this petition was filed that the appellant has sought in directions from the Honorable Court that her salary has not been released, and she claimed she has been rendering as an assistant teacher in Bangabadi ME school and has not been paid salary. And but the writ petition was dismissed by the single judge, and the order was upheld by the inter-court appeal. It means the appellant has also filed a writ appeal before the divisional bench, which also confirmed the order of the single judge. So ultimately, her writ appeal was also dismissed by the divisional bench. Now that both the orders are impinged in the present appeal. The facts which are narrated here in the para number 2 says that High Court, the facts was enumerated. The order passed by the High Court are that on 28th December 1996, an advertisement was issued by the Director of Elementary Education, Assam, for filling up of 7,500 posts of assistant teachers in MEME schools. And the appellant claimed that she has applied for the post and appeared in interview in year 1997. The selection list was not published by Director of Elementary Education, Assam, because the government has issued a ban on the advertisement. After the ban was lifted, the subdivisional selection committee for Udalguri subdivisional in the meeting held on 12th of March 2001 recommended the appellant's name along with other candidates in 3 legislative assemblies, namely Dalagam, Majbat and Udalguri. So appellant's name was appeared against the vacancies, and she was appointed as an assistant teacher in Bangabadi MEM school-wide order dated 12th of March 2001, issued by the District Elementary Education Officer on a fixed salary of Rs 2,000 per month under central government sponsor scheme. According to the appointment order, the terms of the service was up to 31st of March 2002, and she has been working in that school since then. She has not been paid any salary. A direction was sought to the state to pay the salary to the appellant. However, High Court did not find any merit there in the submissions. Before this Honorable Supreme Court, they have made assumptions that the order of the High Courts deserves to be satisfied because she has been working there in the institute, in the school, without a salary being paid, so which is not permissible by law. But the government council have opposed the contentions. They have made a submission. 2001 Director of Elementary Education conducted an inquiry, and by their order dated 18th of October 2001, they declared all the appointments as illegal. 509 appointments were treated as illegal and void ab initio, because these appointments were made against the non-existing post. From the both sides of the parties, the Honorable Supreme Court has confirmed the decision made by the divisional bench of the High Court and has made the reasons in their order. And first, they have considered whether she was appointed as an assistant teacher in Bangabari ME school against the vacancies in Udalguri Legislative Assembly constituency by the subdivisional selection board in the meeting held on so-and-so, pursuant to an advertisement issued by the competent authority to fill up a regular post of assistant teachers. However, now the court has held that no appointment letter was issued to the appellant in pursuant thereof. So it gives rise to some kind of suspicion that since no appointment letter was issued, how can the appellant be in services? So rather, the appointment letter dated so and so 2001 issued to the appellant by the district elementary education officer Darang Mangal Doi shows that she was appointed an assistant teacher in Bangabari ME school, which falls in Mangal Doi, a subdivisional of Darang district. So, as noticed in the impinged order passed by the divisional bench of the High Court, the same does not fall within the Udalguri Legislative Constituency Assembly. It is nowhere stated that the appellant's appointment letter, that the said appointment letter was in pursuant of advertisement issued, or the candidate has gone the selection process for the same. So it means that the letter which was issued by the district elementary education officer, nowhere it was written that she was given an appointment in pursuant to an advertisement issued or the candidates have undergone any selection process for the same. So in fact, all the appointments was made by the district elementary education officer Darang Mangal Doi from 8 March 2001 to 31st March 2002 was declared illegal, void, and ab initio by the Director of Elementary Education, void the office order. Otherwise, the order dated 18th of October 2001. So applicant's name was also included in that the order which was passed by the Director of Elementary Education. So it found that District Elementary Education Officer has appointed 509 teachers illegally against the non-existent post. So appellant did not even challenge that order dated 18th of October 2001. So now the courts has made an observation, since the appellant has got the appointment letter which was issued by the district elementary education officer. So all the appointments made by them by the concerned education officer was declared as illegal, void, and void ab initio. So by the director of elementary education. So neither the appellant has challenged that order, and since she has not challenged that order, so it becomes final in nature. So it has attained the finality, the appointment letter, nowhere it has written that she has undergone any kind of a selection process, or this appointment was made in pursuant to an advertisement made by the authority. So since the appellant did not even challenge that order, divisional bench further noticed that appellant have selected against the vacancies in Udalguri Legislative Constituency Assembly could not have been appointed in a school beyond the jurisdiction of that constituency. Another suspicions court has made an suspicions against the appellant, since she was appointed against a vacancy which was there in a particular district. So she could not be appointed against a vacancy which was beyond the jurisdiction of the said constituency. So the Honorable Supreme Court has only reappreciate the order given by the Honorable High Court, and they has reappreciate the observations also of the Honorable High Court, on the basis of which the Honorable High Court has come into the conclusion. So it's further noticed by the Honorable High Court that appellant has not placed any material on record any material to show that there was an advertisement issue or the selection process had undertaken for the appointment in the school. So means honest lies on the appellant to prove that she was being appointed against the vacancy, and neither she could be able to produce any material or document before this honorable court. So on the basis of which the court could have believed that she has participated in the selection process, and her appointment was made against the vacancy which was advertised. So here the appellant could not even produce the materials before this Honorable Supreme Court of India. So where she was offered appointment and claims to be working. Once the appointment of the appellant has been declared illegal, void ab initio, and was cancelled by the Director of Elementary Education, Assam, by its order dated so and so 8 October 2001. The appellant could not legally continue in services thereafter unless the cancellation order was set aside. So once her appointment was declared as illegal, void ab initio, so the appellant could not perform her duties, since appointment was declared as a illegal, unless court has also made a point that unless her cancellation order was set aside, or some kind of a stay was being imposed on that order. So none of the condition was satisfied against the appellant. So appellant could not produce the materials. Appellant could not give the explanation why she was allowed to continue in services when her appointment was cancelled by the higher authority. So on the basis of this, the court has made their observations. Thus, appellant has no legal right to continue in services, especially where there is no order or letter dated placed on record by the appellant that she was allowed to continue beyond 31st of March 2002. No claim for the payment of salary could have been made for this period. Otherwise, it's difficult to believe that the person who has been working for 2 decades without salary. Even the writ petition was filed in the Honorable High Court in year 2008, claiming the salary from 21st March 2001 onwards, 7 years later. So the case is also hit by some delay and latches too, because she was terminated on year 2001, and she has challenged the order in 2000 after almost a period of 8 years, 7 or 8 years, because the petition was filed in year 2008, 7 years later. So for the reasons mentioned above, we do not find any reason to differ with the concurrent finding of the facts recorded by the High Court. While concurring the reasons recorded by the High Court, the appeal is dismissed. There shall be no order to the cost. After making a detailed observation why his petition is not maintainable, or not maintainable, the court has analyzed all the aspects and then comes into conclusion and that the appeal has no merits and it deserves to be dismissed for challenging the order of the Honorable High Court. So this was the video based on the judgment passed in 22 of August 2023. Hope you have liked this video. If you have liked this video, please subscribe to this YouTube channel, press the bell icon notification button, and like this video so that we can update you from time to time. Thank you.